Legal matter exercise number 25, 840 words at the rate 100 word per minute. Be ready? Start. On an application preferred by the respondent herein under section 11 within bracket 6 of the Arbitration and Conciliation Act 1996, the High Court has appointed an arbitrator on behalf of the appellant herein on the ground that in spite of notice by the respondent in this behalf the appellant had failed to nominate its arbitrator in terms of clause 25 of the agreement entered into between the parties. Since the respondent had already nominated its arbitrator, further direction is given that the two arbitrators shall appoint an umpire in consonance with the said clause 25. This order is impugned by the appellant primarily on the ground that clause 25 was modified by three supplementary agreements whereby the entire edifice of the said arbitration clause stood adhered and on a joint reading the of original clause 25 with modification effected by the supplementary agreements that there was no question of arbitration between the appellant and the respondent at this stage. To appreciate this contention, one will have to traverse through the relevant clauses of the main contract as well as supplementary agreements. Thus, we would like to state along with the events as they occurred in chronology. Stop. In fact, as we proceed to unfurl the events with our comments there and then, we shall be getting answer as well to the issue involved. An agreement was entered into between the Standing Conference of Public Enterprises Scope and the appellant, namely Larsen and Torbo. This agreement was for construction of twin tower office complex at Lakshmi Nagar District Center, Delhi, which was awarded by the scope to the appellant. Originally, contract value for this work was stipulated at rupees 27 crores. Works comprised of the civil works and also subsidiary works that could be ordered from time to time by scope architect. Stop. This agreement was permitted the appellant to subcontract. Accordingly, the appellant entered into an agreement with the respondent. While retaining the civil works with itself, the appellant awarded finishing works including brickworks, woodworks, flooring, furnishing, aluminium works, and other miscellaneous works including waterproofing, etc., to the respondent. It was a pass-through contract on a back-to-back basis. The value of subcontract was stated at rupees 12 crores. Stop. Clause 2 of this agreement pertains to the payments which were to be made by the appellant to the respondent. Amount under this subcontract was payable to the respondent by the appellant only. The position which prevailed up to this stage was that for the works undertaken by the respondent, it could receive the payments only when such payments were made by scope to the appellant. Further, all questions and disputes between the appellant and the respondent were to be referred to a sole arbitrator where the claim was up to rupees 10 lakhs and 3 arbitrators for claims beyond 10 lakhs. The arbitrator was not supposed to deal with accepted matters, no so stated in the certificates. However, even if the award of the arbitrator empire was in favor of the respondent, could not receive payment under the said award unless such a payment was received by the appellant from scope under the award. Full stop. In that event, the respondent was to provide an opportunity to the appellant to raise those claims with scope. On receiving the payments from scope either under the arbitration award between scope and the appellant or otherwise, the appellant was supposed to honor the award passed in favor of the respondent. In essence, the parties understood that as the employer was scope for whom the work was to be performed by virtue of main agreement entered into between parties and the subcontract between the appellant and respondent was on back-to-back basis. Any work done by the respondent was for the benefit of scope and ultimately liability for honoring the claims of the respondents was that of scope and the appellant was not supposed to make any payment from its coffers. The parties even acted on the basis of aforesaid understanding initially. There were certain claims of the respondent and the appellant in turn raised those claims with scope. A settlement was reached between the appellant and scope with respect to those claims whereby the appellant was given a sum of rupees 200 crores by scope. The appellant and the respondent entered into an agreement for apportioning the aforesaid amount whereby a sum of rupees 77 lakhs was paid to the respondent towards full and final settlement of claims price escalation on works due to hindrance caused in execution of work and to complete the balance work. At the same time, another important understanding was also reached between the parties while making apportionment. The modalities of settling the disputes between the parties through arbitrator also underwent a significant change. This is clear from clause of the first supplementary agreement which reads as the agreement provides that all disputes between the parties shall be settled through arbitration. It is now expressly agreed that any dispute or defense shall be deemed disputes jointly between the parties. Stop.